with some of the reasons why people don't sign, I guess there's a number of reasons. Some might be fear, some might be barriers in terms of physical execution or concern about authority and so on. And one question we do get is about translation and whether you're obliged to offer a translator. And certainly at the moment, we don't offer multiple language versions of the agreement, but certainly in terms of talking through the agreement or making sure that residents do understand, it's important to be attuned to that issue. And one possible approach to that is certainly having a reference point for people to go and seek a translator if they need it in their language, so to have explanations or guides in multiple languages so that people can then avail themselves of that opportunity.
Thanks, Solomon. Yeah, you're right. I quickly skipped one of the slides. So this new question is regarding if residents have to sign the agreement and what happens if they do not. So David, do you want to add anything about that? If residents refuse to sign?
I think that the points that Solomon have made is obviously right on the money. Our experience shows that generally speaking, where we get difficulties with signing of agreements would be remote communities as one. Literacy is generally another. Obviously, ethnicity is a third. And the issue tends to come around, obviously, on those 3 points. How do you, in fact, get the understanding for the resident to know what they're signing and accepting in terms of conditions? So having somebody to explain that is important. Interpretation is important. There is a government interpreter service that can be used. And in some cases where obviously people may not have a full understanding, then the appointment of somebody who has the capacity to act on their behalf is really important. And that's where things like medical powers of attorney and so on become a relevant issue in this matter. And, you know, you should seek advice or give advice to your potential residents that they should get appropriate advice in signing those documents or having somebody appointed to act on their behalf. It may well be a public trustee, etc., but somebody else can act on their behalf in this circumstance. Thanks, Mark.
Thanks, David. Question 4. An agreement cannot be signed and finalised until the resident decides on how to pay for the accommodation costs. So this question overlaps slightly with question 2. Since the introduction of RADs and DAPs back in 2004, some providers do not ask the resident to sign and execute the agreement until the resident have decided on how they want to pay for the accommodation costs. They seem to believe the absence of that information in the agreement makes it incomplete, therefore cannot be executed. This, unfortunately, I think has resulted in many agreements left unsigned on omission. So Solomon, can you shed some light on this practice?
Yes, so although residents have 28 days to decide, we wouldn't say that you just wait that time out. As I said earlier, it's certainly preferable to have an agreement signed as soon as possible, and the agreement accommodates that occurring in terms of a choice being made later, and certainly documents that and sets that out. So we wouldn't suggest you hold off. We think it's much preferable to get the agreement signed, and it may be that you implement supporting processes to establish what that choice was later, as in get the agreement signed, but then issue a confirmation to say, we acknowledge that your choice has been now a RAD-DAP combination, or you've agreed to pay the RAD in full and so on, and then have a record of that so that it would sit alongside the agreement. And as per the dot point in the slide, we don't suggest that you need to do a formal deed of variation based on that choice. Again, the agreement accommodates it and has that framework there, so that once the choice is made, you're simply applying or administering the agreement without the need to then go and restrike the agreement or have another deed to support it.
So just a simple letter just to confirming what the client's choice is and having them sign off is sufficient.
Yeah, and I don't even know whether strictly you'd need to get them to sign off. I mean, if it's a record of the discussion or a communication that's been issued to you as to what that choice was, I think it's just more of an administrative process then to acknowledge it and make sure that there's a record in the systems as to what the choice was.
Sure. David, you got anything to add?
Once again, I obviously concur with Solomon's view on that. The situation often that I confront is that people think that the 28 days is a cooling off period. It's not a cooling off period, it's a decision-making period. If the decision is made on day one, acceptance of that decision and acknowledgement by signing the agreement moves the matter forward. and the whole matter is resolved. If the people take the 28 days in which to make a decision, obviously, as Solomon has pointed out, you're still better off getting the agreement signed and then acknowledging the decision at some subsequent date. If the potential resident has been appropriately informed and the discussion has gone on between the provider and the recipient as the resident or their representative perhaps, then the reality is that most of them will understand what the terms and conditions of admission are at the time anyway. And so in most cases, that should not be a problem. But delay is not necessarily in anybody's interest. And I think to get clarity and a decision and then get that documented is obviously desirable from all parties. So that would be my strong recommendation to everybody.
Thanks, Dr.
Thanks, Mark.
Next question. Are agreements that have been signed and returned with amendments made by resident or their family acceptable? So I guess this scenario could happen if you send out the agreement to be signed by the resident or their representatives, and when it's come back, it's signed, but they've made some manual amendments on the agreement. So what should providers do when faced with this situation, Solomon?
Yep, don't panic. Look, I think where we typically see this is in a public trustee, state trustee type scenario. And some of that I think is born out of misconstruction of what the agreements provide. But it is important when you're issuing out those agreements to be quite clear upon what that basis is. For example, setting out that you're issuing the agreement on the basis that if the resident enters, it will be as per the terms. So making it quite clear that you're not entertaining any amendment at all, so as to then position yourself that if it comes back with amendments on it, to then say, well, that wasn't the basis upon which we'd agreed to admit the resident, therefore they're not enforceable against us and we're not accepting them. It's also then important that if you're doing that, to then have a follow-up letter that basically rejects the amendments, because if you sit on your hands and just accept it, and obviously that'll turn on what the amendments are, because some of them you might say in the scheme of things you're not so fussed about. But if you are taking issue with what's come back, then as you will need to go back and set out again what the basis of admission was, and re-establish your position being that they entered, and on doing so they were taken to have accepted those terms as you outlined to them. In terms of some of the amendments that we're seeing, and as I said, I think some of them are a misunderstanding as to how the agreement's applied. Some of them, for example, are around guarantees. There seems to, I think, be a suggestion from some of those state trustee, public trustee organisations that they're guaranteeing all of the obligations of the resident out of their own assets, which is not what the agreement seeks to do at all. And another one similar to that then is the charge over property, that there seems to be an objection taken with that, which I find problematic, because again, it's not seeking to get a charge over the assets of a multi-gazillion dollar organisation. It's simply saying that on administering the affairs or the assets of a client in their context, that the property is then available, no different to any other expectation for another resident that's entering. And so I think on that point of seeking, security, that it's important that you understand what you're conceding, taking into account the potential for those organisations to be quite difficult to deal with in a debt recovery scenario.
Thanks, Solomon. David?
I think in addition to that, the sort of things that I would say, and clearly to the provider, the arrangement eTools went into with Russell Kennedy was that we saw them as being experts in the field, as indeed they are, and therefore the documents they produce not only meet the compliance and regulatory requirements, but they're obviously trying to provide a document which clearly explains the relationship between the care provider and, in this case, the resident. I also very strongly oppose the idea of accepting amendments to the agreement. I think the agreement is fair, it's transparent, it covers all of the matters that I think obviously are important to both the provider and the consumer. And just keep in mind that at the point of admission and at the point of acceptance of the terms and conditions of service delivery, the provider's on an equal footing with the consumer, or the resident in this case. The moment that document is signed, and particularly if it's been amended, the position of the provider can be jeopardised, and you'll live with that jeopardy for the length of the time that that agreement is in place. So keep that in mind. We work very closely with Russell Kennedy, and we also rely on them to provide that legal backing, so that what we provide and present to you is a document that is in fact in your interest to keep intact in the form in which it's presented, and it will be amended as and when the legislation requires that to happen. If there's any feedback or questions that come from representatives and or the resident themselves, certainly pass them on. We will make inquiries as to whether or not there's any reason for the agreement to be amended or changed. But otherwise, we would go with the argument that you should not necessarily accept willy-nilly amendments to the agreement. You also, of course, in closing, have a choice at that point. If a person does not want to enter into the agreement in the form that it's presented, you have the right to say that then you will not provide service. So keep that in mind. It's not as if you're obliged to take a person on their terms. They are coming into the service that you offer based on the terms that you're offering. Thanks, Mark.
Thanks, Doug. Question 6. The next 2 questions are very similar and there's a bit of overlap, so perhaps I can present them together for you to address at the same time, Solomon. So question 6 is relating to when the resident doesn't have a Centrelink assessment. So the question is, should you admit them first and sign the agreement later once that information is received? Question 7, if the resident does not have a Centrelink assessment and do not declare their assets and income, providers want to know, can they charge the maximum fee or what fee they should be charging? So let's just jump back to question 6 for a sec. So obviously it will be ideal for prospective residents to, when coming to the provider, to have a completed Centrelink assessment. But what happens when they do not? Do you admit them first and do the agreement later until that assessment comes in, or you hold off on the actual admission itself until assessment is done? I know some providers overcome this by admitting them on respite to begin with, and once the assessment comes in, they then move them on to a permanent admission. So, what should providers do in these 2 scenarios, Solomon?
So my view is, as I expressed earlier, that the sooner you can get an agreement signed, the better. And as David just commented, circumstances change and people's willingness to sign changes and shifts for any number of reasons. So I wouldn't be backing yourself to get it signed much later on down the track. I mean, I think if someone wants to enter and it's quite clear what the expectation is, that you should get the agreement signed. And as per the bullet point on the slide, the agreement accommodates estimates and has a default scenario for maximum charges. And I think some of the concern perhaps is that if you charge the maximum, costs skyrocket and so on. But I don't think that should drive your admin process in terms of documenting the admission. As I said, there's a process for estimates and then readjustments.
Yep.
Just be mindful with the overpayment that under the fees and payments principles, interest is triggered on overpaid accommodation payments and contributions after 28 days. That's not to say that you have to refund the difference in 28 days, but certainly interest applies. So you just need to be mindful of that. And then in terms of how you're administering those payments or applying credit.
Sure. David?
Yes, my comment on this is obviously, once again, the vulnerability of the provider and the financial ramifications for default on payment. So I concur entirely with what Solomon's been saying. The earlier the agreement is signed, the better. The earlier the decision is made in terms of the Centrelink assessment, also the better. And the third string to that would be payment in advance. As I said in my previous comment, the point at which you admit a resident is the point at which you're on an equal footing with that resident and or their representative, and you set the terms at that point. If you delay or defer that decision and admit the resident, once the resident is admitted to your service, you run into a problem because the circumstances change and the ability to have control over those circumstances also changes. So the time at which the provider has the ability to set the terms and conditions of the service that they offer is the point of admission. So if the person hasn't got the Centrelink assessment, then defaulting to the maximum is the method that one would adopt. And secondly, logic suggests that if you're billing in advance, as we would recommend to most of our clients to protect against the potential of bad debt, then you will obviously have those funds to refund should an adjustment be made. Chasing money from residents is always a problematic issue, and you're better to avoid it if you possibly can. Thanks, Mark.
Thanks, David. Thanks, Solomon. Next question. Okay. Can my facility staff be witness to a resident signing the agreement? I think this is a fairly common practice in the field. You have to pull in the receptionist or whichever staff is passing by the office to come in to witness the resident signing the agreement. So is this practice acceptable, Solomon?
So, look, I think it's better than not having a witness, if I can put it that way, Mark. So the purpose of having a witness is, to verify or validate as to who the individual was that signed. But it's also there, I guess, as a reference point as to what the circumstances were of the signing of the agreement if it becomes an issue. And I guess if it is a staff member, that then allows you to have a record as to who may have explained the agreement and so on. I think the reluctance stems from a concern around duress, influence, undue influence in terms of the person signing, pressure and so on, which I think is a legitimate concern. But that concern to me is not the same as the concern around wills, powers of attorneys and those kind of things. So I think it's important to keep those two streams of thought separate. And I think it's much more significant and difficult if you're allowing people to be involved in the wills, powers of attorney process. That I think is dangerous and has a lot of risks associated with it. It is important with any execution process to make sure that there has been an opportunity to get advice. And I know our templates say that there has been an opportunity, but it is important that you generally, reinforce that as part of the sign-off process. I think a number of providers have run sheets or guides to the agreement that they use in conjunction with our agreement, and we certainly have templates for that, which are there as a sort of, as a run sheet suggests, to go through it and sort of highlight key aspects of the agreement as you're going through it, and then to make a record of that being understood. And I think that some providers even go to the step of like having a separate tick box through all of those items. For example, you've understood the RAD provisions, you've understood the accommodation payments and so on as a bit of a tick the box, so that if people do generally have questions or err in terms of ticking the box, there's then an opportunity to understand why there is that hesitation and then provide some more guidance or understanding for those residents.
Sure. Thanks, Solomon. David?
Yes, I would add a couple of small administrative sort of points to that, and that is that a clear understanding that what the witness is actually witnessing. The witness is not witnessing the content of the agreement, the implications of the agreement, how that agreement will be applied, how disputes are resolved. That's got nothing to do. In this case, the witness is just witnessing the fact that the person signed the document. And should there be a dispute at some point that the person did sign the document, then the witness is there to say they were present at the time and in fact the document was signed. I can understand the reluctance of people to be witnesses because there is an assumption that they could get dragged into a disputed issue and so on. However, once again, I reiterate that what they're actually witnessing is that the person signed the document in their presence. On that point too, of course, it shouldn't be conflated, as Solomon pointed out, with the concept that people would then be drawn into other witness type arrangements where, and most particularly where people seek to do amendments to wills, distribution of funds, something that has a significant ramification which is outside the control of both the provider and any staff member that may be in their employ. You don't want to get involved in those issues. Those issues are issues that should be referred back to whoever the person's legal representatives are or whatever. But I think the provider and their staff should stay well away from those sorts of areas. But signing a residency agreement, I don't think is a major issue for staff. For staff, and it should be put across in that way. Thanks, Mark.
Thanks, David. Question 9. Can resident representative sign the agreement even if the representative does not have a legally assigned authority? So what should providers do under this scenario? Solomon?
So one train of thought is that any signature is better than none, and maybe there's some validation in that. The reason I say this in the slide there's some conjecture about this is because of the way orders, particularly in terms of administration and guardian, are interpreted, and then how powers of attorney are applied in terms of what the strict authority is. And there's been some argument about whether where care decision-making stops and where administration powers start and where the two meet, and where the crossover is. And our agreement does seek to address that in terms of saying that whoever signs does verify that they have authority, but that's not going to obviously change the underlying position whether they actually had it or not. But verify the authority where you can, in terms of you should always ask for copies of administration orders or powers of attorney so that you can see what authority the person does have. If they don't have the authority, then look, as I said, I think there is some validation to this point that some signature is better than none, but with some limits on that. I think if they're dragging people in from the street that you've got no connection with or association with, I think it's a pretty tedious link, and I'm not sure what the point of it is. It might create further problems than it solves. But I think it's certainly different if it's next of kin, children of the resident, and it seems quite clear that they are administering affairs. And in many instances, it transpires after the fact that those people then do go and get a formal order in relation to that person. And I think if that happens and you back to back the two processes, it's certainly better to have that signature there.
Great. David?
Yes, I concur with that. The issue is more of an administrative and practical one, I think, in lots of ways. Most people who seek to be admitted to a residential facility or their family members who arrange that don't normally necessarily go off and do all the administration first. Often it's an event that occurs that causes those decisions to be made, often in short notice, and people then rush around trying to find some accommodation for a loved one who needs support. As a consequence, they may not have all of those supporting documents in place at that time. I think the interim measure that we've tried to accommodate in the eTool software is to provide you with the ability to become a nominated representative. So there's a provision to print off a pre-prepared template letter, which basically just requires a signature. And I think that would be a suitable way to proceed if the circumstances arose where the person didn't have the authority at that time. I totally concur with Solomon that if they subsequently or at that time indicate that they do have formalised authority, whether it's a general power of attorney or a medical power of attorney, etc., that in fact you should get a copy. One other facility within the software, which I think is a great advantage to you, is that there is a scanning facility which allows you to scan these documents up and attach them to the file. I think that's always a good thing to do, so that down the track, if there's any dispute or any concern about these sorts of issues, that you've got all of the supporting documentation in one place and readily available to produce in case there's any disputation. But once again, as Solomon said, this is a process where we're trying to admit a resident into a facility, and a signature, if it's from a family member, would normally be obviously an acceptable position. On that, just sort of, I suppose, one final point. In the time that I've been in aged care, which now spans well over 40 years, I've not seen the signature on a document to become a major issue of dispute. In fact, the only time agreements seem to come into dispute is on the non-payment of money. So, I don't think this is a major issue, but I think you need to formalise it as best you can. Thanks, Mark.
Thanks, David.
Yeah, and just in terms of the payment dispute, I know we'll get to some questions later about charges and so on, but in terms of documents being incomplete, typically that's where we see the dispute, that the relevant boxes have not been ticked in terms of guarantees and charges, which then creates doubt as to whether they were even intended to apply, and then conversely whether they can be enforced.
Okay. Moving on, question 10. Can I do a variation if a resident wants to extend their respite stay rather than doing a new agreement? Yeah, this is a super common question. If only I got $1 every time I got asked that question, I think I can retire by now. So, what is the official position on this, Solomon?
Might have to get some more dollar coins from David, Mark. So the discharge date is obviously contractual in terms of it. It's what your agreement is with the resident on admitting them to respite stay, and obviously it's often tied to the number of funded respite days, but ultimately it is your agreement with them. So if that is extended, then certainly, yes, you can vary the agreement to record that. I don't think you need a formal deed of variation to do that. And we certainly have templates, and a number of providers, I'm sure, have them as well, to issue a letter basically saying, look, we acknowledge that you had a break or that you went into a hospital and you're returning and so on. Therefore, we're happy to extend it. I think the hospitalisation trigger can be difficult for some providers to navigate because there is a presumption, I think, under the agreements and in the system about hospitalisation ending the agreement. So I think you've got to be careful with that trigger. Sure. So if it comes to an end, I think most providers then prefer to document a new agreement, as in reset and go again. But if it's simply that the initial expectation was 7 days and you're going to extend that for another 7, I think you can do that through letters. The templates that we've developed flag the issue about funded and unfunded days, and just, I guess, basically record or flag the issue that if you trip yourself over into unfunded days, then the resident or consumer will have to pay for those days effectively. So just be mindful of that in terms of documenting those variations or extensions. And I guess we have seen that with this extension that it's becoming, I guess, more common or typical because of the Commission's interpretation of security of tenure in respite. And I think a number of providers, you said earlier, Mark, about not having assessments and doing it. But I think there's also been a pattern of some providers doing rolling respite periods so that you don't then get jammed with the security of tenure argument at the other end of it, so that your exposure at worst is 7 days.
Mm-hmm. Oh, I think you've given us some work there. I can just see us getting a spate of emails after this telling us to add in that extension letter into our variation module. So
just ask people to send their dollar coins when they
need more dollar coins from David for sure.
David, I'd add a couple of things. I'd add a couple of things. The first one is, whilst I accept the point Solomon's making that a letter obviously does the job effectively, and even Mark's comments about adding a new feature into the software, the reality is the variation provision within the software, in my view, is only a single one-page letter anyway. And to my way of thinking, it's a good policy to have all of your chain history of this resident's involvement with the provider in one place. So if you use the variation document, then the reality is that you're going to be able to store that information and keep the history sequentially, and that's an important aspect going forward. I'd adopt a policy, quite frankly, where if there's a break in the respite period, then it's a new agreement. If it's just a continuation because a person booked 7 days but then decided that they couldn't, for whatever reason, leave the facility and wanted to extend by 3 days, I think then it's an extension, and that's a pretty straightforward process. Having said that, for those of you who've used the software fairly regularly, there is a provision within that to clone the document anyway, so it's not an arduous task to reset the agreement and reset the dates. Sure. So it's a question of what's the best for each particular facility, but my view is make sure your process, whatever it is documented. If you do a letter, scan the letter into the software. If you do a variation, then obviously once that's signed, it gets stored into the document, into the system as well. So as long as that history's there and there's an acknowledgement that you changed the conditions of that respite arrangement, I think that's fine. The last point I'd make is exactly a confirmation of what Solomon said as well too, and that is be very conscious of the number of respite days a person has and get a sign off from them if it's going to exceed their allowed limit, either to get extension from the department for further respite days, which is one option. If that's no longer available to you, that they agree to to pay the designated fee for the extended respite period. And that's merely just to protect the provider. Thanks, Mark.
Thanks, David. Okay, question 11. Will I need to do a variation if a resident moves room, even when the room price is the same? So we used to observe this quite a bit, where providers are not issuing any documents when residents relocate rooms. So what should providers be doing in this scenario, Solomon?
I think they should be creating a record, as David said, whether that's about the variation of the days, and I think it applies to a room concept as well. And that's to create that paper trail that David mentioned, but it's also to dot some I's and cross some T's as well. So just for context, the agreement does accommodate room changes, as in it clearly says your room is the room that you occupy, and it's got various provisions that talks about change of room and what happens in those scenarios and what MPIR applies and so on. But I still think it's very important to have a process of documenting the reason for the move, which is something that can easily be done in a letter. And again, we have templates for that. What the room is, whether there has been or not been a change to the room price, whether that impacts on the MPIR and so on. So I think it's just good practice to have that system there. If you get questioned on what the underlying reason was and whether there was adequate consultation and so on, it's certainly preferable then to be able to produce the record of that and demonstrate that you did outline to the resident clearly what the implications were and what the basis of the room was and when it was going to happen and so on.
Thanks, Solomon. David?
Yes, that's true. I think the issue of the MPIR is obviously a practical and financial one, and that obviously has impact whichever way the MPIR is moving, and at the moment, of course, it's moving south. The second part of that is to once again maintain the history so that you actually have a recorded history of all changes. There are further aspects though that could be to the advantage of the provider. One of the things that we have been looking at for some time also is to provide additional support to providers by being able to give contemporary information. And one of those sources of information might be, for example, the current layout and where people are in the building or what rooms they happen to be occupying. So if you update the software as we're going along by the changes of room, that will allow us via the information that you store in your database to be able to print out reports that actually have allocations of where residents are within your facility. And particularly if it's a large facility, that becomes a more important issue.
Sure.
So in my view, document it. I think you should formally do that through the variation process, and that will make sure that you accommodate the MPIR changes at the same time. And then you store that information. Part of the process in that variation step, of course, is to get the acknowledgement that it was a resident agreed transfer or a decision that was made by the provider because of some practical reasons such as renovations to the building, et cetera, et cetera. So it's always good to have that documentation there. It avoids disputes down the track, and it means that you can, for practical purposes, obtain further information about the management of your services, which may be of value to you going forward. Thanks, Mark.
Thanks, David. Question 12. Is it necessary to list contacts on the agreement? So Solomon, is it necessary to display all that information which seems to sort of clutter the front page of the agreement? What should they be doing?
Clutter's a subjective view.
That's what we say. That's what we get, the feedback we get. Can we make it shorter?
Yeah. Well, I guess you potentially could, but our response is you've got to record it somewhere based on the records principles. You're obliged to maintain a record of at least one representative, and you're also obliged to maintain a record of other representatives that are notified by the resident. So that is why we include it in the agreement, so that we think it's a centralised record of it. We acknowledge that it can be ever changing and that people's representatives can change, which is a fact that we can't avoid. But again, you have to keep a record of it. So our thinking is that you're best to keep it there as a means of doing so.
Okay, sounds good. David?
Yeah, I've got a few things I'd like to say about this, I think. The first thing is that probably the most common discussion point that Mark and I and the other people in our office confront with our clients and the industry generally, and certainly at a lot of seminars and conferences that I've been to, and that is that the agreement is too long. We want a shorter agreement. We want, literally a one page. Let's all bring it down to a shake hand type arrangement. And all of that's fine. And no one would dispute that would be a desirable outcome if in fact it was sustainable, if it delivered the outcome that we were trying to do, and if it was in the interest of the parties concerned. I think people need to take a breath and step back and say, why is the agreement the length it is? What is the purpose of the agreement? What are we trying to achieve in terms of what's in the agreement? And once you start doing that and you look at it from the viewpoint of what the department legislates, the compliance requirements they put on you, the legal risk factors that you confront, the financial ramifications of not having appropriate clauses in agreements, the explanation of additional conditions should you wish to put them in that are specific to your particular facility and service, and the protection mechanism you need as the person delivering service to your resident. And when you look at all of those aspects, it clearly indicates the agreement needs to be comprehensive. I mean, you may not need to use that agreement at any time during the life of a given resident. And agreements really have no value until the day they have value. And the day they have value, you want the people like Solomon in this world to have well and truly covered your backside, right? So that's the key to the whole thing. In terms of your idea of having representatives and contact points and so on, I'm of the view that as many as possible. If you're engaging with the loved one belonging to a particular family, then you should have contact details that allow you to really understand the family structure, where this person's come from, who they deal with, who would be interested in knowing about the care and well-being of this resident, how you can engage the family more in the care process. Keep in mind that even though a provider is the professional deliverer of service and care to a resident, the primary carer of that resident is still the family or the next of kin. The provider is only one part of the equation. We've got the family members, you've got the legal representatives, you've got their medical practitioners, allied health specialists, so there's a whole plethora of people who come into this, what you'd call combined care delivery process. So instead of us looking at it from the point of view of how to cut down the administrative workload, because that's going to make life easier, we should be looking at the practicalities of saying, why do we do this and why should we do it better? And so I would support the view to say that have one, obviously you need one, but you should have more representatives and you should learn more about the representatives that are involved in the care process of your particular resident clients as well. It's really important for the care process and to be a professional in what you're doing. I think that probably covers off my sort of having a little bit of a rant about that, Mark. So I'll head back to you.
Thanks, David.
We do get a lot of feedback about this, the length, and as David said, we didn't draft the legislation. So to accommodate that, obviously takes quite a bit of drafting. We do have a simplified agreement for some settings, for example, home care, but the feedback we get is that we're not prepared to take on that risk as a provider in terms of we want the full-blown indemnities, we want all of these detailed provisions. So as much as there seems to be concern about the messaging and the way the agreement presents, if it's put back on the provider, it doesn't seem to be that they want to take up a short form. But as I said, we do have some samples, not for a permanent resi agreement, but we do have it for some other instances if people are interested in them.
Thanks, Solomon. Okay, question 13. What are the legislative requirements regarding producing a quote for services and accommodation pricing? So I know providers have the obligation to publish their maximum room prices along with some of the examples of the payment methods. This is usually displayed on the provider's website. So is it still required for providers to convey that information to the resident via a quote document before even drafting the actual agreement itself? Solomon?
Yeah, look, we certainly think you should be providing it directly, and I think your system allows for that. And that's for a number of reasons. One being that you can't ever guarantee that anyone's even found your website for a privacy policy or a RAD-DAP combination sample, etc. And even if they have, it may not be that they even understood it or they thought it was directly relating to their circumstances. So certainly you should be providing that example. And in many cases, people, and I guess this is what your system does, is develop it up as in, you know, the room is 550, for example. This is what it means for you. So it's not just a general vague example of what it might be to anyone walking in off the street. It's actually for them, and they understand what it would mean for them and the implications of the combinations and so on.
That's correct. David, you got anything to add?
I think this really is probably one of the most significant parts, in the sense that, keep in mind, from a lot of providers' viewpoints, there's unfortunately, from our perspective anyway, there seems to be a reasonably high turnover of staff. And I think the idea of providing a quote, in addition to the points that Solomon has raised, is that it walks the provider's representative through the process of explaining to the family member, representative and or consumer, in this case the resident, the options that are available and to allow them to be informed about which option is best in their circumstances. So I think the quoting arrangement is really, really important. And also, of course, what it does do is it retains the evidence within the software of the process that you've gone through, so that once you have done that, it triggers all of the necessary functional options that then provide on how you go forward in terms of managing the lump sum payment or the daily payment and so on. So I think from that viewpoint, it is a very good procedure to follow. And as I said, it also tends to be advantageous in the position where you've got a new staff member who would find it difficult, perhaps, of explaining to potential residents what the conditions are and what the options are in terms of their pricing choices. So I think that's really important. In terms of the second point that Solomon made about having documents stored elsewhere, I mean, I totally agree with that. I think the old adage of the keep it simple, stupid approach to life is well worth considering. If you, in fact, are bringing to the attention of a potential resident all of the information they need to view and understand at the time of that initial agreement to enter the facility, then basically you've cleared up most of the situations at that time. And that gives you an opportunity to explain anything that they may misunderstand, or at least elaborate on the information that you're offering, so that there's no confusion. Now, 99% of all providers probably have very few issues between themselves and their residents in terms of the understanding on that admission process. But there is a lot of paperwork involved, and as we've discussed, a large agreement. But the support you give them in doing that, I think, is going to be beneficial in that you will not have any problems going forward. So I'm very much in support of the idea of providing a quote and a printed out quote. Also, I should add, sorry, one thing I didn't cover was additional services. At the point of admission, when you're doing that quote, one of the other things you have the opportunity to do is to fully explain to potential residents what additional services is all about, why it can enhance their life, and why it gives them a consumer-directed choice on additional services that they may wish to access within the facility. So if you don't offer additional services, that's another aspect to the quote, which I think is definitely worth looking at and will differentiate your service from the one down the road. That is, what range of additional services are you prepared to offer? What's your pricing structure? And how can you encourage people to improve their day-to-day lives by the range of services you're offering within that quote? So I'm very much in support of it. Thanks, Mark.
Thanks, David. Question 14. Okay, this is another very common questions we get asked. Given that the current, I think, base rate is 2.25%, which is obviously much higher than the current bank deposit rate, providers are obviously keen to refund as soon as possible to avoid the financial loss each day the RAD is being held. So, Solomon, when a resident passes away, can providers refund the RAD before probate is received?
Well, they certainly can decide to if they want to, but it's not without risk, and in some instances quite significant risk. And that risk is that you pay it to the wrong person and then you refund the thing twice because it's been squirreled away or it's gone to the wrong person and you haven't discharged your obligation to pay it to the right person, being the estate of the deceased resident. There are some steps to mitigate that. We have a template checklist that sort of allows you to try and understand what that risk is. For example, understanding whether you genuinely believe that you know the family in terms of whether there might be unknown children and so on out there. I don't know that it totally mitigates the risk, but allows you to make some sort of assessment of that. And on that, I'd note that, we often get told, oh, we've got the will. And we say, well, how do you know that's the actual final will? That could have been the will from 3 years ago. So as much as you believe there's no risk, there's never any guarantees around that. We do support that with a deed of indemnity, which seeks to record that those who receive the payment, if it turns out they received it incorrectly, they will refund it or they'll meet the liability in connection with that. But again, that's not perfect in terms of you obviously got to enforce the indemnity. There are mitigation steps which, in terms of how you pay it, for example, insist upon paying it to a lawyer's account to try and involve them in terms of it having paid to the estate, for example, so that if someone banks it or purports to act upon it, then they are in the gun as well in terms of why they distributed it or how they satisfied themselves of it. We are aware that there's been a trend of people getting irrevocable authorities, and the intention with that seems to be to record that the repayment was triggered immediately prior to death so that you avoid the probate scenario, and that you're effectively then almost converting, I suppose, from RADs to DAPs just before death. There is another approach here that if it's genuinely believed to be someone else's money, that you record that at the outset so that at the time of admission, you actually use a third party RAD payment arrangement. We have templates for that, and we back to back that with an additional condition that we suggest that you include in the agreement to record that someone else has contributed the RAD, that it won't be paid to the estate, but if it's deemed to be part of the resident's affairs, it may impact on payments and so on. And then with the person that has paid it, acknowledges that you will treat it as though it was available for refunds and deductions and so on. And then at the balance, they will get back whatever there is available.
Thanks, Solomon. David, just keep in mind, we've got 5 minutes left. We've got 2 more questions to go.
So. I'll be very quick on this point. The point Solomon made about getting the document signed where a third party has provided funding on behalf of a family member is incredibly important. It's probably the one key issue that I've come across most over time where family members are angry that they have in fact provided the funds on behalf of the resident, and it goes into the resident's probate arrangement. So I would definitely refer you to Russell Kennedy to get the document to provide to third parties who make payments. I think that's an excellent addition. Secondly, obviously the issue of people ringing us regularly saying, can I make the payment? I want to make the payment now. I don't want to hold on to it because of the potential interest rate implications, particularly as the current prevailing interest rate in the bank is very low. I would strongly suggest you don't do that. It's a risk factor that you don't need to take, nor should you take. You can mitigate that to some extent by ensuring that any resident coming in does nominate a solicitor up front. And from time to time, you confirm that that solicitor is still a current solicitor related to the consumer, so that you can consider the option of liaising with that legal firm and saying, we wish to disperse this money to you now, so that you can do that as part of your probate management. And that at least is a better outcome than just sitting on it. So I think it is a mitigation issue. So preparation and planning is really important. Put in place the right mechanism and you'll minimise the amount of damage, risk and cost to yourself. Don't pay out the money because you may well in fact find that there's a dispute over the probate or a dispute over the way the money's been distributed, and you will find yourself right in between the rock and a hard place, which is not a nice place to be. Thanks, mate.
Thanks, David. Okay, so we're now up to the last 2 questions, and both of them relates to the security for payments in the sections in the agreement. By default, we have disabled these sections in NERA, and providers have to actually make a conscious decision to re-enable them before they will reappear in the agreement. I know most of our clients have now enabled those sections, but For those that have not, Solomon, can you share with us what is the purpose of having security of payments, and what other things providers should be considering before they introduce it as part of their resident agreements? We'll start off with guarantors, perhaps.
Yeah, so start with guarantors. 2 questions in 2 minutes. David will keep it brief, guaranteed.
Yes.
They're both forms of security, as you said. And the guarantors are in many ways about seeking leverage. And as I put in the slide, it's really sometimes tied to the security for payment in terms of the charge. So the guarantee requires the guarantor to effectively meet any liability that the resident doesn't meet. So it allows you to spread the risk in terms of recovering from multiple sources. That obviously assumes then that the guarantor has some money, and it assumes then that you're prepared to go and pursue them to get that money out of them. So if they've got no money, it's pointless. But if they do, and you think the risk of bankruptcy or getting them into proceedings will give you leverage, then it's a good tool to get the security. And as I said, it's often tied with this charge over the property, because often the guarantor, if it's a relation, will be the person who stands to benefit from a sale of the house in terms of a distribution on death. So if you get an acknowledgement from the guarantor that they can't take any assets before you are paid, you can then try and put the two together and make sure that they don't purport to take any distribution before you're paid. So I don't know if you want to flip to the next one quickly.
Yep.
Mark, I know your time. So the charge over the property, and again, both of these have to be ticked for it to apply. A charge isn't a mortgage. It's certainly only giving you an interest in the property in terms of a warning to the rest of the world. So it allows you to put this caveat on title. If you don't have the caveat on title, no one else out there is going to know about this charge, and it's not really going to have any practical effect at all. So there is a decision that you need to make about when you register these caveats, if at all. And typically it seems to be that most people do it when they think they've got a bad debt scenario brewing. And if you do register your caveat, it sits on the title, and then if someone goes to sell the land, they have to get the caveator's consent. So what it's really trying to do is give you a backstop such that if there is a material asset out there, that at the time someone goes to sell it, you're able to put your hand up and say, we are owed X dollars, we want to be paid, and once we're paid, we'll consent to this dealing.
Sure. Should we keep David on mute? David, really quick, we're overrun by 2 minutes, so you're going to have to keep it really brief. No, you need to unmute yourself, mate. I'm not doing, David. I'm not purposely doing this, by the way, guys. I think that's a sign for us.
The comment I would make is that the guarantor is just more of a moral thing, which is basically saying we will pursue the debt. Can I just say in both these cases, in some states, of course, putting a charge on is more difficult. Sometimes you can't put them on in perpetuity. I mean, there's a whole lot of arrangements. You need to get legal advice on that as to what sort of charge you put on and so on. The second thing is that if you manage your resident financial situation appropriately, bill in advance, bill monthly, make sure debts are received and charged and paid in full, follow up any doubtful debts and pursue your rights, then the reality is you can minimise the risk, which I think is the better option than having to, after the event, try and pursue somebody for money. Firstly, it'll cost you money to do that. Secondly, there's no guarantee of success. Thirdly, having been personally involved in it, and I've been going through VCAT now for probably the last 4 years. Fortunately, it doesn't cost me anything, because otherwise it'd be an absolute waste of time, because at the end of the day, there'll be no money. So I would strongly advise you to make sure that you pursue the money up front, make sure you are paid in advance, make sure you're in a position where you will do the refund. Thanks, Mark.
Thanks, David. So that brings us to the end of our webinar today. Solomon, do you have anything to add before we conclude?
Only those who are getting a bit of freedom back in Victoria after tomorrow, enjoy that, and hopefully it's ongoing.
Thanks. Just a reminder to all the attendees, we have recorded the session and we'll be forwarding the link to all the for you to access over the coming days. Thank you once again for your participation, and have an awesome afternoon, everyone.
Thanks, everyone. See ya.
Thanks again, everybody.